Court Uncut, what the people want.
Good morning, sir. You're Corey Flemings? And Mr. Flemings, and is it the same in each case, or was it an agreement for a dismissal in one, or?
It was intended to run concurrent about the 8 years.
Okay, and did you do two pleas? Okay, they're both here? Okay, I'm sorry, I just saw one. Mr. Flemings, in cause number 24, DCCR 2144, you're charged with the second-degree felony offense of assault on a peace officer from September 11th of 2024. That indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, September 27th of 2023. And what that means is that if you go to trial and you're found guilty and that prior offense is true, the range of punishment would be between that of a first-degree felony, which is between 5 years and up to 99 years or life in prison. Do you understand?
Yes, ma'am. I'm sorry to interrupt.
Yes.
Your Honor. I believe the defendant's criminal history lends itself to being a habitual offender, and I have every intention of following the habitual offender notice.
Okay, and Mr. LeBlanc, did you go over that with him as well?
No, you and I talked about that outside.
Oh, as far as the
25 to 99. Yeah.
So, the state has information, he says, that you have more than one felony conviction from before. So if that's true, if you have at least two that are from different dates, and you are found guilty, that changes this from a first degree up to a habitual offender status, which is a minimum of 25 years in prison, up to 99 years or life. Do you understand?
Yes, ma'am.
And in cause number 24 DCCR 2145, you're charged with the state jail felony offense of injury to a child, elderly, or disabled individual from September 11th of 2024. That indictment alleges several prior state jail felony offenses. And when I say several, I mean 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 prior state jail felony offenses. It does not allege those prior regular felony offenses, but if you have, again, two regular felonies that are sequenced, not on the same day, in that case, it would make it a second-degree felony offense for punishment purposes, which has a punishment range between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
Judge, I'm sorry to interrupt again. I want to correct the record. I misspoke. Mr. LeBlanc and I talked about it being enhanced to a regular first degree.
Okay.
5 to 99. We
Okay.
didn't specifically talk about the 25 to 99. I don't want to.
Y'all did it, but you do have the prior, so it could be. Y'all just didn't discuss it.
Yes, ma'am.
Okay, so, but you understand now, I've admonished you, and you understand, and you know what your history is. If you have a prior felony, two prior felonies that aren't state jail, and you're found guilty, then the minimum punishment is 25 years. You understand?
Yes, ma'am.
And that's on the assault case of a peace officer, and the other range of punishment in the injury to a child would be 2 to 20. You understand?
Yes, ma'am.
Okay, and so I have here on the computer plea bargain rejections that you've signed with Mr. LeBlanc that shows that the district attorney's office has made an offer of 8 years in each of those cases to run concurrently, which means at the same time. You have every right to reject that, have your cases set for trial. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial?
Yes, ma'am.
All right, we'll get it set for trial. Mr. LeBlanc will begin preparation for trial. You go back with the bailiff. All right, ma'am, you're Casey Bean?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
Sure.
Ms. Bean, in cause number 23, DCCR 2068, you're charged with theft of property in an amount more than $2,500 with previous convictions, which is a third-degree felony, from April 6th of 2023. The indictment alleges you were previously convicted of theft September 4th of 2014, December 22nd of 2015, December 6th of 2017, December 7th of 2018, and June 24th of 2019. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? And then in cause number 23, DCCR 2069, you're also charged with theft of property with previous convictions in an amount more than $2,500 from June 25th of 2023. And how do you plead to that charge? That's also alleges all of those same prior offenses. And are all of those same prior offenses true? And in this case, did you enter your plea of guilty freely and voluntarily? And because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
You also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law.
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Ms. Bean is not competent?
No, Your Honor.
All right, ma'am. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 23, DCCR 2069, find sufficient evidence to find you guilty, and at this time find you guilty of theft with previous convictions in an amount above $2,500. Sentence you to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that the law gives you the right to receive. In addition to that, I will give you credit for any from the date of indictments in each of these cases, which is from November 29th of 2023. So you will receive credit from November 29th of 2023. Y'all have marked that on here as 624 days. I'm going to assume that y'all did that math correctly. But it's for sure from the date of indictment on each case. Do you understand? And then in cause number 23, DCCR 206, which one did I just do?
6-8, was it?
You just did 9. I think you-
Well, I did the plea papers, but then which one did I make the finding
I'm
on?
not sure, Judge.
That I made the finding? Okay. In 23 DCCR, you good? Sorry. 2068, I'm also going to find sufficient evidence to find you guilty, and at this time find you guilty of theft with prior convictions in an amount above $2,500. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Correction. You will also receive credit on that for any time that you've been in custody that the law gives you the right to receive, and also specifically from the date of indictment, which is November 29th of 2023. These two cases will run concurrently, which means together at the same time. I have handed you the trial court certification in each case that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Ms. Holmes. All right? Good luck to you, ma'am. You can go back with the bailiff.
And a GPS. That's your bond. Yes, ma'am, we'll just need to set it for our contested. hearing.
Are you going to plea on the motion? Have y'all talked about it?
Well, he has a new aggravated robbery.
There's a new aggravated
So
robbery.
they'll have to be proved up.
Okay. So we're just gonna enter pleas on the motion?
He'll enter pleas of not true and request a hearing. Yes, ma'am.
Mr. Kidd, raise your right hand the best you can, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand down. Will he waive the formal reading of the motion?
So waived.
Mr. Kidd, in cause number 21-38744, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation November 16th of 2022 for the offense of robbery, a second-degree felony, and that was a 10-year deferred probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true? Count 2 alleges that you failed to immediately report your arrest to your probation officer from March 24th of 2024. Is that true or not true? Count 3 alleges that you were in an establishment licensed to serve alcoholic beverages March 24th of 2024 in violation of your probation. Is that true or not true?
That's true, I was there, but it was in.
Hang on, I just need trues or not true. Count 4, I'm sorry, I skipped 3. That was count 4. I'll enter a plea of true for count 4. Count 3, count 3 alleges that you failed to provide proof of filing or attempting to file your taxes for the year 2023. Is that true or not true? Count 5 alleges that you were at a location other than your residence at approximately 1:20 a.m. March 24th of 2024. And is that true or not true? Count 6 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true? I'm sorry, not true. Count 7 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true? Count 8 alleges that as of April 16th, 2024, you were $400 behind in payments of restitution to the victim. Is that true or not true? Count 9 alleges that you were behind in your court-assessed fees in the amount of $761 as of April 16th of 2024. Is that true or not true? Count 10 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true? Count 11 alleges that you committed the new offense of aggravated robbery February 19th of 2025. Is that true or not true?
Not true.
Count 12 alleges that you failed to report to the Jefferson County Probation Department since April 16th of 2024. Is that true or not true?
Not true.
Count 13 alleges that as of March 3rd of 2025, you're $1,813 behind in your fees. Is that true or not true? All right, so did you enter your pleas of true to counts 4, 5, 8, 9, and 13 freely and voluntarily? Those are the counts that you pled true to. Nobody forced you to plead true to those, did they? All right, then I'm going to find counts 4, 5, 8, 9, and 13 true, find sufficient evidence to find you guilty and revoke your probation. However, I'm going to reset your case for a sentencing hearing. Mr. Smith, if you will check into obviously that new case, we will set some time appropriate for you to bring witnesses and get any discovery that you can get to Mr. Kimler before that date.
Yes, sir.
Okay?
I'd say you're gonna proceed on the administrative case also, you know, but not sure.
We'll make sure we have plenty of time for you.
Ordered an updated PSI.
Yes, and I'll get an updated pre-sentence
Those will
report.
all be addressed by should be addressed by the probation.
They should, and we'll make sure we have that probation officer here as well for those administrative hearing issues. And then whatever you need as far as time for the new offense, we'll give you plenty of time for that.
And in the event that he posts bond, he needs to report to the probation department to schedule for that pre-sentence report.
All right, you can go back with the bailiff.
Make sure to like and subscribe so you don't miss crazy courtroom moments like this one.